on today's episode of Retrial Podcast.
21st century must read the 14th Amendment just as ratifiers did. Interestingly enough, what rights did those people have in their heads at that time? Of course, people did not ratify the 14th Amendment. Men did. Whew. So it is perhaps not so surprising that the ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty or for their capacity to participate as equal members of our nation.
Of course, the beauty of the Constitution was it said nothing for it. It said nothing against it either.
That's exactly right. Welcome to Retrial Podcast, where we decode legal history that happened in Dayton, Ohio. These cases, lawyers, and stories set the stage for present-day learning across our nation. Hosted by trial attorney, the great historian, David Greer, and myself, Judge Gerald Parker. We're back.
And not so great, but good enough.
We are back. Season 2, they brought us back. What do you think?
I think it was nice of them to give us a non-controversial topic to start with.
Here we go. So here's the thing. Retrial Podcast was great, season 1. We are back. And when we started season 1, we started with the Dayton desegregation cases and how they move forward, and even till today, what we're seeing today and the ramifications of that. So now we are starting with abortion. I know, abortion. That, when you say it, you already know that folks who hear the word, their minds go one way, go the other. I want to make it clear the Dayton Bar Association and its supporters, and Dave and I will not be taking any particular position on this matter. Our job here is to teach everyone about some of the cases, particularly a case that we're going to learn about, and just, of course, see what's happened in the law as it pertains to the abortion cases stemming from Roe v. Wade, Planned Parenthood versus Casey, and then, of course, the recent Dobbs decision. So we don't take any position one way or another. However, we are going to go into it in depth and teach y'all a little bit about the history of the abortion cases, which, mind you, a lot of the legal research that I do, and you as well, there's very, very little litigation prior to 1970 to look at. I mean, that something happened in the 1970s, maybe a little bit 60s, where this issue really took off.
The only thing before that would be indictments of people who performed abortions.
That's absolutely correct. Yeah. So what are your thoughts on that? I mean, I was not around in the 60s. You were.
Yeah.
Did you start hearing about these types of cases? Did you know, were they going on and people weren't talking about it as much? Like, what are your thoughts, Dave?
Well, there was one most talked about case in Dayton because we had a local gangster of some renown who ran protection rackets, loan sharking, dog fights, had a variety of businesses, but one of them was an abortion racket. And he had women coming from Kansas City, from St. Louis, from everywhere to get an abortion in Dayton.
Wow.
He got indicted. I wasn't involved in the legal side of it, but I had a buddy that I'd gone to high school with who was in his OB/GYN residency at the Miami Valley Hospital. And the women's ward at Miami Valley Hospital was packed with women who were having terrible things happen to them following abortions, all sorts of difficulties, death, loss of limbs, you name it. And one night the gangster comes up and talks to my buddy and says, are you the witness in this abortion case that's coming up? And he says, well, yeah. He said, are you married? Do you have children? Where do you live? Questions like that would make the average person kind of nervous. Didn't bother this guy at all. He wasn't tuned in. So he grabs this gangster by the shirt, drags him into the next room, says, see that woman in that bed over there? She almost died last night because of a botched abortion. See the woman in the next room? Same thing. So that was my first introduction to abortions, and there were cases about it in those days, pre-Roe versus Wade, but they were criminal cases of.
Yeah. And the Supreme Court talks a little bit about that. We're going to talk a little bit about how we got here. What I find very interesting, there was a recent article, not recent, it was about a year ago, I should say, but in Time magazine, it talked about, how things shifted. There's very small kind of litigation, like this litigation we see today, not the criminal type litigation, the civil litigation prior to 1970. And then here we are now, what shifted. And in that article, it said something, and there was a paragraph that I thought was quite interesting. And it said it is unlikely that the pro-life cause could have withstood the forces of the sexual revolution, because remember, we're talking about the 60s, the feminist movement, and the social changes of the 1960s. The pro-life movement succeeded because it drew on the same language of human rights, civil rights, and the value of human life that inspired the struggle for African American freedom, the feminist movement, anti-war protests, and the campaign for the rights of gays and lesbians. I never really thought about how the pro-life movement began and how it had to draw on the similar manners and ways in which the 1960s movements pushed forward in order for the pro-life movement to move forward.
And when you talk about the law being the quote law, it's amazing how it is nudged and budged and moved around by social forces that exist.
Yeah.
My favorite quote is from Benjamin Cardozo, the great justice, sitting on the Supreme Court after many years in the top court in the state of New York, who said that the only guarantee we have in this country of justice depends upon the personality of the judge.
Why are you looking at me when you say that?
Well, everybody says they're getting justice over there in your court. Sounds all right.
I agree. I just felt like that was like kind of a personal attack on me. I don't know.
No, accolade.
No, accolade. Okay, I'll take it. So I think it's important for everyone to understand, with the most recent Dobbs decision that came out, we're talking about, of course, Dobbs versus Jackson Women's Health Organization and decided in 2022. In Dobbs, the Supreme Court reviewed the constitutionality of Mississippi's Gestational Age Act. This was a law that banned most abortions after 15 weeks of pregnancy, with the exceptions for medical emergencies and fetal abnormalities. A little bit of history. In that opinion, of course, it was a divided opinion because that's where we are right now. The court upheld the Mississippi law and overturned Roe versus Wade 1973. Also overturned Planned Parenthood versus Casey, 1992, and it concluded that the Constitution does not protect the right to an abortion. I'd like to kind of go through what the justices said briefly, just little snippets. I guess this is what the opinion is like, it's like 400 pages long. And I read it last year, and my eyes were crossed, and I was like, okay, it took a while. It was a pleasure reading? No, I wouldn't call it a pleasure. I'd rather read something else. I need to read one of your books that you've written instead of that decision, I'll be honest with you.
Mr. Alito is not gifted with the penmanship of Shakespeare.
Or Dave Greer, to be honest with you.
I don't know.
So Justice Alito comes out the gate and says, in Roe v. Wade, the most critical line was drawn at the end of the second trimester. And it corresponded to the point in which a fetus was thought to achieve viability, the ability to survive outside the womb. Of course, that's what we know as viability. And then in Planned Parenthood versus Casey, the court revisited Roe and concluded that stare decisis applies, which is basically precedent. If the previous court ruled this way, we should follow the previous court's ruling. Is that what your understanding is, Dave?
True enough.
All right. So Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin. Of course, this is Justice Alito speaking. And the three justices who authored the controlling opinion called for the contending sides of national controversy to end their national division by treating the court's decision as the final settlement of the question of constitutional rights to abortion. So during this time, 26 states have expressly asked that this court that we are seeing and that we know of that can be very controversial today, they have expressly asked this court to overrule both Roe and Casey and allow that the states to regulate or prohibit pre-viability abortions. You follow me? That's where we are. Okay. So then Mississippi asked to uphold the constitutionality of this this ban prohibiting abortions after the 15th week. And in that, Justice Alito says that we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion. No such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. So it doesn't say it. It does. The word abortion is not even in the Constitution.
It wasn't really a hot topic back in the 18th century.
I don't think, and they actually address that as we move forward. But there's a lot of words that aren't in the Constitution. Some view it as a living, breathing document, and then you have your originalists or your textualists who think it says what it says. And if it doesn't say it, then I guess leave it up to the states or however. What are your thoughts?
Hard to get a bunch of old men and women to agree, right?
That's true. It's true. You come to my house.
Living, breathing, or dying and gasping. I'm not sure which it is.
That's true. So Alito takes the hard stance. Justice Brett Kavanaugh, the issue before this court is not the policy or morality of abortion. The issue before the court is what the Constitution says about abortion. The Constitution does not take sides. He says that on the question of abortion, the Constitution is neither pro-life nor pro-choice. How this decision will affect other precedents involving issues such as contraception, marriage, again, Griswold versus Connecticut, of course, Loving versus Virginia, Obergefell, and Eisenstadt versus Baird, those decisions regarding gay marriage, interracial marriage, contraception. Overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents. That's what Chief Justice Brett Kavanaugh says. So he kind of lightens things up, says, hey, just chill out. These other decisions, even though they aren't also in the Constitution, doesn't mean that those will be overturned.
And then the next batter comes up to plate, and he says something a little different.
Who's up next to bat? Justice Clarence Thomas. He states in this decision, in future cases, we should reconsider all of this court's substantive due process precedents, substantive due process, what is fair, essentially, under the law, including Griswold versus Connecticut, Lawrence, Obergefell as well, because any substantive due process decision is demonstrably erroneous. We have a duty to correct the error established in those precedents. So Justice Thomas says we need to take a look at all of these decisions as whether to correct any type of error established in those precedents.
So we're just starting down the road.
Yeah, correct. Going back in time, essentially. Then I find interesting Chief Justice John Roberts, who takes the more measured approach, and I'm not making that up. He says, I would take a more measured course. He said that, okay? I agree with the court that the viability line in Roe versus Casey, Roe and Casey should be discarded. There's a clear path to deciding this case correctly without overruling Roe all the way down to the studs. Recognize that the viability line must be discarded, as the majority rightly does, and leave for another day. He says leave for another day whether to reject any right to an abortion at all. Because if we just kick the can down the road, that'll smooth things over, right?
Well, that's what he said.
Okay, all right. Now, he goes a little bit deeper into the 15-week ban. He says that ample evidence suggests that a 15-week ban provides sufficient time. It is no surprise that the vast majority of abortions happen in the first trimester. Whether the previously recognized abortion right bars all abortion restrictions prior to viability, such that a ban on abortions after 15 weeks of pregnancy is necessarily unlawful. The answer to that question is no. There is no need to go further to decide this case. He kind of wanted to say, we'll just deal with this law where we are here, not overturn Roe, Casey, and leave the other issues for another day. All right. So now we're going to switch. We have a 6-3 decision. We're going to switch to the dissent. Justices Breyer, Elena Kagan, and Sonia Sotomayor. Not surprisingly, let me just say, if you read the dissent, I don't know if these are opinions or this is a speech or the words that were used and what was said in the dissent are pretty pretty intense. They basically say for a half a century, Roe v. Wade and Planned Parenthood have protected the liberty and equality of women. Roe held and Casey reaffirmed that the Constitution safeguards a woman's right to decide for herself. The government could not control a woman's body or the course of a woman's life. It could not determine what the woman's future would be. Respecting a woman as an autonomous being and granting her full equality meant giving her substantial choice over this most personal and most consequential of all life decisions. They go on to say that today the court discards this balance. It says that from the very moment of fertilization, a woman has no rights to speak of. Again, I'm just reading from the dissent. 21st century must read the 14th Amendment just as ratifiers did. Interestingly enough, what rights did those people have in their heads at that time? Of course, people did not ratify the 14th Amendment. Men did. Whew. So it is perhaps not so surprising that the ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty or for their capacity to participate as equal members of our nation.
Of course, the beauty of the Constitution was it said nothing for it. It said nothing against it either.
That's exactly right. So this court will surely face critical questions about how its new approach applies. They conclude, these dissenters, by saying, must a state law allow abortions when necessary to protect a woman's life and health? And if so, exactly when? How much risk to a woman's life can a state force her to incur before the 14th Amendment's protections of life kicks in? Suppose a patient with pulmonary hypertension has a 30 to 50% risk of dying with ongoing pregnancy. Is that enough? And short of death, how much illness or injury can the state require her to accept consistent with the amendment's protection of liberty and equality? Further, the court may face questions about the application of abortion regulations to medical care most people view as quite different from abortion. What about the morning after pill, which actually we're getting there already, IUDs, in vitro fertilization, also getting there, I think in Alabama.
Yeah.
And how about the use of dilation and evacuation or medication for miscarriage management? Lastly, they state, with sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection, we dissent. Whew.
Yeah. Well,
all right.
You started out by saying that we were not going to tip the scale as to what our own personal feelings may or may not have been.
We are not.
I've probably got a confession that I should, or a disclosure that I should make.
Okay, what's that?
I was involved with my friend Al Gerhardstein in 3 separate lawsuits which invalidated 3 separate Ohio statutes.
Oh, wow.
On constitutional grounds, as those grounds existed in those golden days. The first was before Judge Rice, and we knocked out a statute that I think was a parental consent. I can't remember what the exact issue was. Mm-hmm. Second one was in front of Judge Rice, again, invalidating a state statute which banned late-term abortions. And the third was up in Columbus in front of Judge Marbley. And I think that was a number of days sort of thing. Mm-hmm. And so I was stopped on the street some time ago by a young man who said, are you for or against abortions? And I said, I'm neither for them nor am I against them. I'm not a woman. It's not a decision I'll ever have to make. But I think it's got to be the most personal and private decision a woman ever has to make in her life. Right. And I would not step in her shoes. Oh, and by the way, I've represented the abortion clinics and represented abortion clinics invalidating abortion strictures and statutes. That just means I'm a lawyer. I represent whoever I represent. But I also have a recollection of the Monty Python skit on Every Sperm is Sacred, where they've got a scene out of the old movie Oliver where all these kids are dancing around and babies are dropping all over the place. So,
what was that like? What was that like to represent, those clients?
It was very interesting. The statutes were not that interesting because it was all medical type expert testimony. the man who invented the late-term abortion, who was vilified everywhere and had to drive around in a bulletproof car, really did it because there are some women who it's a life or death thing at the end of a pregnancy. And he invented the late-term abortion, and the attack on that was, oh, it's awful, dismembering the fetus and so forth, which is exactly what happens in an early abortion. So that went by the boards. But the fascinating thing about this whole subject is how the law changes as society changes. Yeah. And you think society follows the law? No, the law tends to follow society. And we're now watching the interesting phenomenon of what society is doing to move the law around a little more.
Yeah. Can you talk a little bit more about the Dayton case that you're familiar with and that took place here?
Yeah, I represented an abortion clinic and was involved in a lot of picketing. Mm-hmm. And the picketing was pretty severe. It was almost equivalent to, you remember old Simon Kenton having to run the gauntlet with the Shawnee Indians in Ohio, where they whack him and so forth. Yeah. And the beautiful thing about all these people who testified, who had been part of those picket lines, were that they all told the exact truth, which is a nice thing to happen in a courtroom, as you know.
That's what we were looking for.
And I had one guy who could have been a linebacker on the Green Bay Packers or some big team. And I said, now, isn't it true that we've got these little 13 and 14 suicidal girls who've had this terrible trauma in their life? They're coming to the abortion clinic to try to do something about what's happened to them, and they're scared to death. It's got to be the most traumatic thing in their lives. And isn't it true that you would occasionally, as they went through this picket line, grab them and shake them, and claim they were murdering their children and blah blah blah, all that kind of stuff? And he said, "Oh yes, but sometimes when the spirit gets in me, I got to respond to the spirit." And I said, well, God bless us all.
Wow. All right. I think there was a story about some threats that took place, either on your life or some of the other attorneys that were.
Well, yeah, I had just emerged from all the school desegregation stuff, where plenty of death threats were coming around.
So you go from school at the same time, school desegregation.
It all calms down, then here comes all the abortion cases, and wow. They really, in fact, I can remember a golden day when a group of picketers with placards walked by my house with a big sign that said, "Dave Greer kills babies." They weren't going to picket me. They were heading down to Judge Marr's house, who lived in the Oregon District too. Right. And he's able to tell you about that experience in his life, and the experience of being in that case where you had a conflict between constitutional rights, mm-hmm. the right to human privacy and dignity versus the right to assemble and the First Amendment right to say what you think.
Well, let's make that transition then. Let's hear from Judge Marr, if we can, and hear what he had to say about that time period when he was handling those types of cases.
Oh boy, I guess you were part of I think what I still think was the most significant and interesting case, the women's clinic case.
Oh, the abortion picketing.
That where, and the side story to that is that they wound up picketing my house on a Saturday morning. But that case presented, a law school classic between the right to privacy and the right to picket, but the coup d'etat was when on a Saturday morning I wake up and my son Adam is with me, and he looks out. I had blinds, shutters, and he looked out and I was in the kitchen. He comes out and he says, "Daddy, there are people on strike outside your house, outside the house." And I went, "What do you mean?" I look out, and there is going around the house, and there was an alley, and there was a back alley to my house, classical Dayton, with all the alleys. And there they are with the signs, all the things that they depicted on their signs, and chanting and going around. Again, wanting me to overreact and get excluded because it was whatever they were not getting what they wanted. Classic. So I put Adam in the car, backed out, and they never saw me leaving. So they wound up picketing an empty house for a couple hours. I was proud of the fact that it was an example of how it works in this country in terms of a different viewpoints, strong different viewpoints clashing, but allowing the court to figure out a way to moderate it so that both the rights, I mean, they wanted to close it, of course, and they weren't going to get that, but they could picket it, legitimately do that, but they couldn't impede women who wanted to exercise their rights to have an abortion if it was their choice to do that. And I wound up getting an invitation to attend so the women's judges had an association that I didn't know existed. And they were meeting out in Seattle, or I think it was Seattle, and because of this case, they invited a common pleas judge to come and speak to them and he couldn't come, and I don't know who could put my nap on. I got a call from, she became a federal judge from Cincinnati, but she called me up. She was president of the association, and I wound up getting invited to go out and speak about this case. And I also, Mary Marr, the president of Ireland, was also a guest speaker, and I got to meet her and spend time with her. So it was really a plus side that I got out of that whole experience was attending. And then I asked them, I said, can a man join your organization? And they looked around and said, well, yeah, we wouldn't discriminate, So I was the only male. I became a member of the National Association of Women Judges.
So what I found interesting about the pro-life movement, most think, and the media even portray the pro-life movement as a Catholic cause, but by 1972, those stereotypes were actually outdated because in Michigan, the fight against a referendum to legalize abortion was spearheaded by 3 Protestants, a gynecologist, a white Presbyterian mother, and an African-American woman who was a liberal Democratic state legislator. In Minnesota, the leader of the state's pro-life campaign was a liberal Methodist whose physician husband was a member of Planned Parenthood. In Massachusetts, one of the leading pro-life activists was an African-American Methodist physician who had been the first Black woman to graduate from Harvard Med School. And even in New York, where Catholics accounted for the vast majority of the movement's activists, there was more religious diversity than the media often acknowledged because Catholics had joined forces with Orthodox Jews. One of the keynote speakers at the April 6th pro-life rally in Central Park was an Orthodox Jewish rabbi. Some of the most vocal pro-life advocates, one being a liberal Lutheran minister who is best known for his protests against the Vietnam War and his advocacy of civil rights. So early on, I don't think you could just pinpoint who was pro-life and who was pro-choice.
And I've always been bothered by the phrase pro-life. It suggests that if you aren't against abortion, you must be pro-death, and
Right.
that's insane.
Well, what's even wilder is we're going to go talk a little bit about death penalty at a future retrial podcast
Yeah, how about
episode.
pro-life for those poor guys?
Hey, well, stay tuned for that one. We'll discuss the
Or
death
all those-
penalties in Ohio coming up.
What
as well.
was it, 120-some thousand kids killed in Gaza recently, and you look all over the world, there's trouble everywhere.
Well,
And the curse of being a child in a world where you don't fit and you're hated and you're brought up in a home where they bang you around. We had one of our finest judges had a daughter who got married too early, had a baby too early. She and her husband fought all the time, throwing pots and pans at each other. One of them finally threw the baby, and the baby ended up with brain damage for the rest of its life. Wow. It's a complicated world, I guess is all you can say.
yeah.
And if you look at it from the ground level, the idea of all those women dying from illegal abortions or being terribly ill, all those little 13 and 14-year-old pregnant girls scared to death and wanted to kill themselves. All these other things. Pro-life for those people means something different. And if you want to take it up to the height of Mount Olympus and look down at the world, we've now got a little over 8 billion people in the world.
Yeah.
It took us, 300,000 years to get to 1 billion people in the world. And then it only took another 222 years to get to 8 billion.
Right.
And it keeps going up because birth rates and death rates don't coincide. It's a terribly complicated thing, which is beyond the reach of any decision, it seems to me.
Right.
And we're now going into a real interesting phase of the law, where what do the different states do?
That's a good point.
You wouldn't want to be a sperm floating around in the state of Alabama, apparently, although every time a man ejaculates, there are 8 billion sperms that are set free. And every state now has got a different way to swing at the problem.
Mm-hmm. Yeah. Well, let's talk about that as we conclude. Here in Ohio, as we know, there was a special election that was held, I believe it was August 8th of 2023, where there was a referendum to make it substantially harder for voter-led initiatives to amend the Ohio State Constitution. What does that have to do with abortion? Well, it's said that that amendment was in order to restrict any type of referendums and essentially placing, legalized abortion as a constitutional right. Well, that voter-led referendum, that voter-led initiative on August 8th was rejected. In fact, the requirement stated that any proposed amendment to the Constitution of the state of Ohio shall receive the approval of at least 60% of eligible voters voting on the proposed amendment. So obviously making it harder to amend the Constitution, with the understanding that there was probably a referendum to constitutionalize abortion. The legislature wanted to kind of get ahead of the game. So that gets turned down, and then a few months later, Ohioans on Tuesday, November 7th, 2023, voted to approve a constitutional amendment that would create a right to abortion in the state of Ohio. Ironically, by almost 60%. I always find that pretty interesting. So that constitutional amendment was recently created, that right to abortion in the state of Ohio by almost 60%. That's just where we are.
So where we end up is that the law doesn't follow, the society doesn't follow the law, the law follows society.
It sounds like it.
And maybe the only justice we have is what the great justice said, the personality of the judge.
Yeah, the personality of the judge. Well,
your day is coming, my friend. Who knows what's on the docket for next week?
I can't wait to see what's coming on my docket. You know, it's sad when you're like, can I just hear a next, I don't know, is there at least a murder or a robbery or burglary?
We'll find some problems for you there.
Yeah,
you haven't had a capital case.
Well, I haven't, but we'll talk about a few in a few weeks. But
okay.
But as we know, abortion is a very, very sensitive topic, and the goal is to inform everyone as to legally how we arrived here. Hear a little bit about what took place in Dayton, Ohio. Dave, we started off with a bang, man. I appreciate this. It's always fun gaining your knowledge, and we've got more work to do because we got some more cases to talk about. The next episode, we're going to be talking about NCR. The next episode, we are going to learn about NCR, who they were in the community, and the antitrust case that took place and how that resonates here today. So that's going to be a fun.
Good news is that nobody had an abortion in that case.
Oh my gosh.
And nobody got sentenced to death penalty.
That's the good news?
Yeah.
Can't wait.
That'll be an easy one.
Can't wait. Thank you all, and tune in next time of Retrial Podcast Season 2, Episode 2. This Dayton Bar Association and Dayton Bar Foundation project was funded in part by a grant from the Dayton Legal Heritage Foundation and the Jack W. and Sally D. Eichelberger Foundation of the Dayton Foundation.